My name is Leslie Fisk. I'm here with my colleague Lindsay Jacobs today because we want to talk to you about the basics of representing a victim of domestic violence in a custody and visitation case. This program is designed for people who are new to family court or attorneys who haven't practiced family court in a while. I've worked at South Carolina Legal Services for the last 10 years. I work primarily in family court. I'm the head of our family law unit. About 60%, I'd say, of my clients are domestic violence survivors, and I'm also a volunteer mediator at the Upstate Mediation Center.
Like Leslie said, I'm Lindsay Jacobs. I'm an attorney in Greenville, South Carolina. I've spent my career representing domestic violence and sexual assault survivors in myriad civil matters, family court, of course, but also in education, employment, and the criminal law context.
The reason we wanted to talk to you about domestic violence is because it's such a huge problem in South Carolina. And if you do any work in family court, it's very likely that you will come across survivors of domestic violence. Just to give you an idea, in 2015 for SCADVASA, all their member programs had over 18,000 emergency hotline calls in 1 year. Another statistic from the Centers for Disease Control in 2010, their survey found that 1 in 4 women and 1 in 7 men had experienced severe abuse in their lifetime. So this is a very common problem, unfortunately.
South Carolina recently ranked 5th among states for the rate of females killed by males, and that was a report from the Violence Policy Center, and that report comes out every year, and every year South Carolina ranks very highly, unfortunately.
And we also want to note that not all domestic violence is a man being abusive to a woman. I've represented men in domestic violence relationships before. I mean, no matter how strong the man is, if you have a gun in your face, that is abuse. Also, same-sex couples experience domestic violence as well. So we are going to try to avoid saying he and she, but if we do, please know that we do understand that domestic violence occurs in every demographic. One of the first things that we think you should do if you take on a case for visitation and custody for a domestic violence survivor is to adjust their expectations. Sometimes victims will come to you after they have been through a very serious episode of abuse, and it's very hard for them to understand that just because they've experienced domestic violence does not mean that they're going to get custody of the children. It also doesn't mean that the abuser's visits with the children are going to be limited. Domestic violence is a factor, which we'll discuss as we go along this program, but court cases are decided on a case-by-case basis, so there are no guarantees. So adjusting those expectations is one of the first things I have to do with my clients.
And it's important to remember that the Supreme Court of the United States has said that parents enjoy a fundamental right, a constitutional right to parent their children. So it's difficult to deny a parent, to absolutely deny a parent visitation with their child.
The overriding standard for family court is the best interests of the child. It's also important to know that mother and father do have equal rights. So some of my clients come in and say, well, because I'm the mom, I should have custody. The tender years doctrine, which used to exist, has been abolished. Mom and dad are on equal footing, and it really does depend on the cases and the facts. I've had plenty of clients who are men get custody. When the parties are married, they start out completely even rights. Either party has the same rights to the child. When they're unmarried, it's presumed that mom has custody until dad brings a court case. And once he brings a court case, they're again on even footing. But if they're not married, then she does have custody until they go to court. I've listed the statute here for the factors that the family court considers. I'm not going to read them all to you, but I do think it's important for you to look at them and realize how in-depth these family court judges have to go to make decisions about who should have custody of this child. In South Carolina, we do have a part of our statute that says that domestic violence in the relationship should be considered when making a custody determination. Once again, this is just one of several factors, but I've listed the statute there for you. It's also important to know that if the victim left the marital home, for example, I say marital, but left the home they were living in because of abuse, that should not be counted against him or her when the custody decision is made. So for example, the other side couldn't say, she left us, me and the children alone, if it really was to avoid the domestic violence. That should not be counted against the victim. There are several different types of custodial arrangements in South Carolina. Sole custody generally means that there's one person who's making all of the decisions, the important decisions such as legal, educational, religious decisions, medical decisions, and then usually the other party has some visitation. Joint custody can be sort of a confusing term because it's broken down into two different things. You have legal custody and physical custody. Legal custody is who makes those big decisions that we were talking about, the educational and the religious and the medical and all of those big decisions in the children's life. Physical custody means who the kid lives with, primarily. So a lot of times you'll see where parties have joint custody, but one person has primary physical custody or primary physical placement, and that generally means that the children are with that parent more often. Shared custody usually means when people have more of a half and half split, which works for some couples and doesn't work for others. For visitation, when the court makes a decision about visitation, they are looking at several factors again, primarily the children's best interest. Generally, courts do believe that children need significant time with both parents in their lives. However, they may look at how far the parents live apart, what the non-custodial parent's schedule is like, when figuring out what a reasonable visitation schedule would be. The courts seem to be leaning more in a direction of more visitation these days. It used to be, maybe Friday through Sunday, every other weekend, and now we see them adding a little bit more, such as perhaps a few hours on a week in the evening to give them a little more time with the children. It's also important to know that both parents have the right to the children's school records and to participate in the children's school unless a court order says otherwise. So most judges really do encourage both parents to be involved that way. Once again, we have a statute that says domestic violence should be considered when the court's making a decision about visitation. And once again, it doesn't mean they're not going to have visitation, but the court is supposed to consider it. And when visitation is ordered, to make sure that it is safe for the child and for the victim. So some things that I have seen that we've done either in agreements or the court's ordered to help make that safer would be, for example, mom drops the kids off at dad's mother's house, so paternal grandmother's house, an hour before dad comes, then dad picks them up from his mother's house. Not only does this make grandma happy because she gets some time with the kids, but also it avoids mom and dad running into each other and maybe having a violent incident. Sometimes we ask for visitation exchanges to be at somewhere public, such as McDonald's or Walmart or police stations.
I have noticed that judges don't love using police stations because I think that they think it might negatively impact the child to constantly be driven to the police station and exchanged between the parents. So I'm finding that they're less and less likely to use the police station unless the violence is really egregious or there's a real threat. I would also say for supervised visitation in my practice, I prefer using visitation services. So in Greenville, we're lucky that we have third-party visitation services, and those cost money. Often the victim could ask that the alleged abuser pay for cover the cost of the supervised visits, but they're great because it's a third-party neutral, and in my experience, they write reports on the visit, so you actually get a detailed, essentially a readout of what occurred during that visitation. So if the parent were saying anything inappropriate to the children or something like that, you're going to know about it because it's included in that report. So I'm a big fan of supervised visitation using third-party services.
That's a great point, and I believe there are some in Columbia as well, probably something that'll be more likely in the larger cities, but it's worth looking around and seeing if it's available near you.
Sure, and it is certainly more difficult I recently had a case in Darlington County, and that was not something that was available in that area, unfortunately.
When we're talking about visitation schedules, we talk about parenting plans, and depending on where you are in the state, will probably determine which ones are used the most often there. Sometimes judges have a favorite, or sometimes the attorneys in that region tend to use one over the other. Where I tend to practice in the 8th Circuit, we have an 8th Circuit standard. We also use Judge Brown's standard pretty often. They all vary a little bit, so what we want you to know about this is if you're negotiating with the other attorney, for example, and they say, will you agree to all the standard visitation and restraining orders? You should not just agree because it's standard, because it might not be what fits your client's situation the best. You should say, I'm sorry, I'm not familiar with those, or do you have a copy of those that I could look at and go over with my client, because you don't want to agree to something that's really going to set your client up for failure or for being in contempt at some point. For example, most of them say, no paramours overnight. And if you know that your client lives with her boyfriend or his girlfriend, and you know that maybe that's important because of the income, that continue to happen, you would not want to agree to those and set your client up for contempt. You would agree to some of them, for example, or might look for a different set of restraining orders to agree to.
And you can so Leslie referenced Judge Brown's standard visitation guidelines. Those, I think you can find them if you do a Google search, but certainly any family law practitioner in your area, you could reach out to them, and I think they'd be willing to share those. And I use those as a baseline. I don't think that they often work really well in cases where violence was prevalent in between the parties. So I always use it as a starting point, and then just like Leslie said, I'll modify that based on the needs of my client, particularly with regard to their safety concerns.
We just wanted to let you know that there are other statutes out there that may affect different parts of your case. For example, if this custody dispute is part of a divorce case, the domestic violence that occurred can affect the property division and possibly alimony if that applies in your divorce case. Other ways it may affect how your case turns out and what's best for the children include discussing a way for the parents to contact each other that's safe. And this is often not only protection for the victim, but also protection for the alleged abuser, that there are not going to be any allegations that aren't true, because there's some sort of record of how that communication has gone. Often we will, if it's very severe violence and recent violence, we may ask that the communication be by text or by Facebook message or some other way that's traceable. I know there are also some systems out there some judges have been ordering, such as Our Family Wizard and other similar websites.
And if there is a protection order in place, often that will include a no contact element, and generally when those are issued, the judge will say no contact except as it pertains to the minor child, and I think the suggestion is almost always that communication take place via text message so that there is a written record.
Also, we often agree on restraining orders against harassment, excessive contact, or contacting each other when the communication isn't about the children, things like that when they're necessary. Usually, as long as it's mutual, that you can get the other side to agree to it, and it helps set up some expectations for how the communication is going to go in the future.
And I generally will, if I can get away with it, or if the other side will agree to it, I like to include some of the language from the protection order. So Judge Brown's restraining orders, the standard restraining orders, they don't really address how the parties interact with one another. It's generally how they act around the children. So I will take some of the language from the protection order and try to integrate that into maybe a temporary order or the final order.
That's a great idea. We appreciate your attention. Thank you for listening.